I'd like to call the meeting to order. It is 9:17, and could we begin with roll call?
Rodney Diaz, otolaryngologist and board member.
Karen Chang, public member.
Amnon Shalev, hearing a dispenser, board member.
Marcia Raggio, audiologist, board member.
Dee Parker, speech language pathologist, board chair.
Patty Solomon Rice, speech language pathologist, board member.
Debbie Snow, public board member.
We have established that we have a quorum, and at this time, we are going to go into closed session. Oh, no, I want to introduce you first.
We're not going to, I would suggest no closed session.
Oh, no closed session, okay. I'll turn it over to our administrative law judge, Karen Brandt, and thank you for being here this morning.
It's my pleasure. Good morning. My name is Karen Brandt. I'm the administrative law judge with the Office of Administrative Hearings who's been assigned to preside over these matters. Today, we have scheduled on the agenda 2 petition hearings. The first petition hearing is a petition for reinstatement of surrendered license by Taryn Crocker, license number 7542, OAH number 20180100355. And our second petition is a petition for penalty relief by Marian Blanchard, license number 8627, OAH number 20180100497. We have our Deputy Attorney General here today. Would you please?
Good morning. My name is Megan O'Carroll of the California Attorney General's Office.
All right. Let me see if we have our court reporter here. Good morning.
Good morning. I was told 9:30.
You were in fact told 9:30, and we will not be going on the record till 9:30, so you can have plenty of time to set up. But before we go on the record, I have been told a few things about the potential for the first hearing, and I wanted to let Ms. O'Carroll put it on the meeting record before we go on the hearing record. So, Ms. O'Carroll, with regard to the petition for reinstatement of surrendered license by Mr. Taryn Crocker, I understand you've got some new information about it.
Yes, Your Honor. As you know, today is the time on the agenda for the petition for penalty relief, for reinstatement, actually, of Mr. Taryn Crocker of his hearing aid dispenser license 7542. We are learning that Mr. Crocker is not here today. He has not shown up. And while normally we would seek to proceed in default, we are, however, unable to establish that the notice of hearing that's contained in your exhibit binders was in fact received by Mr. Crocker. And for that reason, we'd request that the matter be put over for the next board meeting.
It's my understanding that Mr. Crocker was given notice that this hearing would begin if he was given notice. The notice would have said to him that it would begin at 9:30.
That is correct. However, and you'll actually see that in the exhibit binders in front of you at Exhibit 13, where it states 9:30. However, that particular document was emailed to Mr. Crocker, and although I was previously under the impression that he had responded and acknowledged receipt of that email, it turns out now that no, he had email exchanges with board staff about that hearing date, but it turns out that once the actual document at Exhibit 13 was sent to him, that there was no prior response. And we've also learned that, and this is a matter of public record, which is available on the Santa Clara County's court website, it appears that he has in fact, his current status is in custody. And the result of that is that we cannot be assured that he did receive notice of today's hearing, and rather than be concerned about violating his due process rights, we request that the matter be put over for the next hearing, at which point during the interim, board staff and I will contact him and see if he wishes to withdraw his petition for reinstatement or if he does in fact want to go forward.
It's now 9:22. I have found in the past in hearings that I've done that petitioners have a way sometimes of finding out about hearings even if actual notice can't be established. It would be my recommendation to wait until 9:30, see then if he shows up, and then let the board determine whether this matter should in fact be put over for another hearing. Would that be acceptable to you, Ms. O'Carroll?
That sounds like an excellent resolution.
Would that be acceptable to the board members?
I have a question. Do you have a system to send notices to people in legal action like the civil system or
That is something that the board does.
we send this notice?
Yes, and then you notify us, OAH, to come to the hearing. So we get your notice.
So how is the defendant or the petitioner in this case get served?
I will defer to your board counsel about how the process is for your board to serve it.
I don't advise the board in that arena.
Who's
I do not know who is responsible at your board for serving notices. Are you aware, Ms. O'Carroll?
My understanding is that the enforcement coordinator will take that, and my recommendation would be simply that it be served by mail with a proof of service for all future matters. But that it
That's
also
my-
would be a good idea if we know, for example, that he is in fact located somewhere else, even though to ensure proper procedure, it be mailed to his address of record. It's also a good idea to send a courtesy copy, for example, to the county jail.
It would also be my recommendation to always have the notice for the time that your meeting starts for all of the hearings you may have, whether you're having 1, 2, or 3. That is usually the most efficient way to do things.
Yeah, but I find the serving with an email it's not sufficient, to my opinion.
I will leave that up to the board to make a determination on. So shall we wait till 9:30?
I think that's a good idea, Your Honor.
And when it is 9:30, we will go on the record. When we do go on the record, the way I will do it is I will ask all the board members to identify themselves again, so our court reporter will have it down in the record. And then I will call on Ms. O'Carroll to identify herself and to present that if our petitioner is not here, he's not here, and how she would recommend that we proceed. Is that acceptable to the board? All right, we'll wait until then, until 9:30. All right. We are now back on our meeting record. I will tell us when we'll go back on the hearing record. I see it is now 9:32, so let's get on the meeting record. Let's also get on the hearing record. We are now on the record, both our meeting record and our hearing record, before the Speech, Language, Pathology, and Audiology and Hearing Aid Dispensers Board for 2 petition hearings. The first petition is a petition for reinstatement of surrendered license by Taryn Crocker, license number 7542, OAH number 2018010355. The second hearing is a petition for penalty relief by Marian Blanchard, license number 8627, OAH number 2018010497. My name is Karen Brandt. I'm an administrative law judge with the Office of Administrative Hearings, and I have been assigned to preside over this matter. In order to ensure that there is a quorum, I am going to ask that each of the members identify themselves, starting first with the member from my furthest right.
Debbie Snow, Public Board Member.
Patty Solomon Rice, Speech Language Pathologist, Board Member.
Dee Parker, Speech Language Pathologist, Board Chair.
Marcia Raggio, Audiologist, Board Member and Vice Chair.
Amnon Shalev, Hearing Aid Dispenser, Board Member.
Karen Chang, Public Member.
Rodney Diaz, otolaryngologist, board member.
There is a quorum. May I please take the appearance of the Deputy Attorney General?
Good morning. I'm Megan O'Carroll of the California Attorney General's Office.
I note that there has been no appearance by or on behalf of Taryn Crocker, and I understand, Ms. O'Carroll, that you have some information you would like to provide to the board about that.
That is correct, Your Honor. As you noted, today is the time and the place scheduled for the hearing on the petition for reinstatement filed by Mr. Taryn Crocker. The board has in front of it a series of binders with documents providing the information behind this case, which is board case number 1C 2017-027. Mr. Crocker filed this petition for reinstatement, and the board duly scheduled it for hearing today. And Mr. Crocker was sent notice of this hearing. However, we're unable to establish that he did in fact receive that notice, and as a result, we're requesting that the matter be put over for a final determination at the next board meeting, between which time board staff will be able to obtain and present evidence that he did in fact receive notice of today's hearing. Of the hearing on his petition for reinstatement.
So you're requesting that this matter be put over so that Mr. Crocker can get proper notice and be fully served with the date and time of the new hearing. Is that correct?
That is correct, Your Honor.
All right. Is the board in agreement with all that? Shall we ask each board member in a row? Let's start with Ms. Snow.
Yes.
Yes, I'm in agreement.
Yes.
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 Yes, I agree.
Your request that this matter be put over is granted. This matter is put over to a new date and time. I will allow the board to choose that date and time after giving proper notice to Mr. Crocker and making sure that OAH is in fact notified as well.
Yes, Your Honor.
All right. We are off the record for our hearing for Mr. Crocker. Do we have any information about the next hearing for Ms. Blanchard in terms of whether or not Ms. Blanchard is here or ready to proceed?
We do have information, Your Honor. The information is that she is planning on appearing today. She was given notice of the hearing date and time for 11 o'clock this morning. However, she's indicated to board staff that she will be able to be here, she believes, by 10 a.m. and will be willing to proceed at that time.
All right, why don't we go off the record until that time, and when she shows up, we will go on the record again and start with our hearing. We are off the record. You're welcome. 10's better than 11.
protest. I mean,
Okay. We're now back in open session. And to begin with, is there any public comment for items that are not on the agenda? Okay. Then we'll move to item 10, approval of the May 11/12, 2017, August 10/11, 2017, and October 26 and 27, 2017, and the December 28, 2017 board meeting minutes. Item 10 in our packet.
So May 11, 12, this is just coming back?
Yes.
D.
Patty.
Did you want to ask for any revisions to any of the minutes? Or do we need to pass a motion first, or?
Has everybody read them?
Yes.
Okay.
I have just a.
I have revisions. I have revisions.
I don't have a revision, but I just have a question. Because I'm new, I wasn't here, except for the last one. I would feel more comfortable abstaining. So
You may abstain from the vote on the ones that you do not want to participate in. So,
Okay.
Madam Chairwoman, if you want to take them each individually, or that might be the best way to do it in order to incorporate Karen's vote.
So we'll start with May 11th, 2017. Are there any revisions or comments? Okay. None heard? Is it? Yep.
Move to approve.
Second.
It's been moved and seconded to approve the minutes. Is there any discussion? Heard any comments from the public? Okay, none heard. We'll call the roll.
Yes.
abstain.
yes.
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 Yes. Okay. Minutes are approved. Next.
Looks like August 10, 11, this next one.
Okay. If there are simple edits, we don't need to make those comments at this time. We can turn them into the board. The next is August 11th, or 10th and 11th, 2017. Are there any revisions or comments?
Talk about the locked hearing aids disclosure being tabled. I'm not sure what the plan was for pursuing that. Tabled until, this is page 5 of the August 10, 11, top of the page, under 12.
I think the minutes accurately reflect what took place in the meeting, and at that point, it was tabled.
Yeah, I understand that it was tabled.
I don't, we could probably talk about that as a future item of discussion.
Has it been
If the board-
agendized for another meeting?
We don't have the agenda for the following meeting yet, but we could put it on there.
I mean, when something's tabled like this, you guys keep the staff keeps a running table and brings them back at some point? Or only if the board wants to?
It depends on the board. We have a list of action items that we keep, an informal list, and if there's something that needs to be brought up, we'll usually do that. We have some other items that we've tabled in that manner.
Well, I'd like
So I
to
think
see
it
that one
depends on
come back.
priority.
We need to make a decision about it.
Okay.
Any other comments? And from the board? Any comments from members of the public?
There a motion to approve?
Oh, motion to approve?
So moved.
Second.
It's been moved and seconded to approve. We'll go the roll call.
Yes.
Abstain.
Yes.
Aye.
Yes.
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 October 26th through 27th? Oh, just the next one?
The next one, yes. The next minutes are October 26th and 27th, 2017.
You have a hand over here.
Patty?
Yeah, I have a couple of revisions to those minutes. On page 2, item number 4, update from the Speech Language Pathology Practice Committee. The final sentence says the committee reviewed 1996, 2004, and 2013 ASHA guidelines, and it was noted that the only difference between the 1996 document and the 2013 document was the elimination of the ASHA credentialing of SLPAs. Actually, that 2013 should be 2004. It's actually an important content change. Also, so what I would suggest that you say something to the effect of, again, the sentence would be changed to, the committee reviewed the 1996, 2004, and 2013 ASHA guidelines. It was noted that the only difference between the 1996 document and the 2004 document was the elimination of ASHA credentialing of SLPAs. You might want to add a comment that the 2013 document did not discuss curricular guidelines. And I have one more minor but important revision. Okay, this is on page 4. Under item 11, discussion and possible action regarding supervision requirements of hearing aid dispenser trainees. In paragraph number 2, on line 4, it starts out saying to clinical well, I'll say the whole sentence. Ms. Solomon Rice opined that as the hearing aid profession changes, the competency level should change, and referenced the audiology educational change from master's to clinical doctorate. And then in parentheses, this is PhD. It should say AUD. I realize that's just, probably a typo, but it's an important change.
Mm-hmm.
Those are the revisions that I have.
Any further revisions? have a motion for the minutes as amended?
So moved?
A second?
It's been moved and seconded. Discussion? Any comments from members of the public? Okay. Thank you. Then let's call the vote.
Abstain.
Abstain.
Yes.
Yes.
Yes,
Yes.
those minutes are approved. Final one will be the minutes from the telephonic meeting that we had on December 28th. Any comments?
Everybody there present correctly? I'll move to approve.
Second?
It's been moved and seconded that the minutes be approved. Is there any discussion? Or any discussion from members of the public? All right. Then we'll call the vote.
Yes.
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 Abstain?
Okay. Motion carries. We'll now move to item number 11.
So this is a report on the Speech Language Pathology Practice Committee, which took place yesterday at 1 o'clock. The purpose of this particular meeting was really a fact-finding meeting to obtain more information about speech language pathology telepractice, and in particular, are there issues of concern that should be discussed and potentially put forward as regulations regarding speech language pathology telepractice. We invited a expert in the area, Melissa Jakubowicz, who is who has a business in telepractice and also is the coordinator of the American Speech Language Hearing Association Special Interest Group in telepractice, known as SIG 18, and so is a national leader in the area of speech language pathology telepractice. So as I say, this was a fact-finding mission more than anything else, and I think everyone agreed that we found out some wonderful facts. So it was a very useful piece of information from her. I thought I'd summarize. Would you like me to summarize what I thought were the major points of what she discussed? Okay. So she started out by first stating that in the Department of Consumer Affairs, the term that's used is telehealth, and she differentiated that from the term that is typically used in speech language pathology, which is telepractice. And the reason for the different terminology is because telepractice and speech language pathology is provided in a wide variety of settings beyond the healthcare settings. So, in fact, the majority of telehealth practice in the United States by speech language pathologists is in the schools. So that is why she mentioned that she would continue using the term telepractice rather than telehealth for her particular report. She reminded us that telepractice is a mode of service delivery. It's not a type of practice. And there is certainly not a one-size-fits-all when it comes to telepractice in speech language pathology. There are a variety of different service delivery models providing telepractice in group settings, providing telepractice in individual settings, providing telepractice in a variety of different settings such as schools or hospitals or skilled nursing facilities or private practices. So there's a wide range of mode of service delivery in this area. and that it is within our scope of practice to provide this type of service delivery model, and that it is up to the speech language pathologist to use their sound clinical judgment, their expertise, their knowledge and skills to determine whether this particular service delivery model is an appropriate service delivery model for the type of client that they are, or patient or student that they are providing services to. She talked briefly about evidence-based practice and stated that there is over 20 years of research in the area of telepractice to provide us with the efficacy of this particular service model delivery. She spoke about barriers to providing services of speech-language pathology and telepractice, the primary barrier being technology, that some settings simply do not have adequate technology to be able to provide these type of services. In particular, she referenced internet speed, and she referenced technical assistance as needed when issues arrive. She also talked about regulatory barriers because oftentimes services are provided across state lines. In other words, the speech-language pathologist is in one state and the client, patient, student is in another state, that speech-language pathologist is required to have licensure in whatever state the client, patient, student it resides in. So there's the cost of licensure. And in addition to the speech-language pathologist having a variety of licenses in a variety of states, that means that the speech-language pathologist also needs to keep up with the licensure regulations and statutes in each of those different states as well, and that can be a barrier. She talked about reimbursement barriers. Medicare does not reimburse speech-language pathologists for telepractice, so that really impacts the whole area of patients that are Medicare eligible or have Medicare. She did mention that Medi-Cal does reimburse for services, and that might very well be the reason why the vast majority of services through telepractice are provided in the schools, because then the school can bill Medi-Cal for the services provided in California. There's also the equipment costs for telepractice as another barrier. She also talked about, and then mentioned, this is a little out of order, but this is when she mentioned it, that 60 to 75% of telepractice services are provided in schools, a very high level. Perceptual barriers. Some speech-language pathologists are opposed to telepractice services, and as a result of that, they're concerned about they might lose jobs to others who can provide services in a wider service delivery area, the quality of the services, et cetera. So there might be some negative perceptions of providing speech-language pathology services through telepractice. We asked her about what are some of the main regulatory issues of concern in the area of telepractice, and she said overwhelmingly the greatest concern is in the area of supervision. How do we supervise individuals speech-language pathologists providing services through telepractice, in particular required professional experience supervision in the state of California and student supervision in the state of California, both which impact licensure of speech-language pathologists. She discussed that providing telepractice services is not an entry-level type of skill to have, and that there is inconsistent training of telepractice services at the university level. She stated that perhaps the RPE candidate or the student who's being supervised might be able to obtain clinical hours on a part-time basis, but it certainly shouldn't be 100% of the hours that they are obtaining to work towards completing their master's degree or to work towards their permanent licensure in the state of California. Also, there is an issue about the supervision of speech-language pathology assistants when the speech-language pathology assistant is in one location and could possibly be in another state and the supervisor it could be in a different location in another state. So the issues of supervision are issues that should be on our radar and should be an area that we're considering if we want to move forward with any type of regulations in this area. She also talked about current regulatory barriers. She mentioned that her practice isn't based in California, and she has not seen barriers to providing telepractice services in the state of California as far as our current regulations are concerned. It was mentioned that there might be some concerns about speech-language pathology credentials to practice in the schools, and it was mentioned that that is really an issue that needs to be delved into by the Commission of Teacher Credentialing. That would not be an issue that we could deal with. We don't have any regulatory control over the speech-language pathology credential in the schools. Continuing education was another topic that she brought up. What type of continuing education, should there be continuing education requirements for individuals, just as we have continuing education requirements for speech-language pathologists who supervise CFs? Should there be some type of continuing education regulations for speech-language pathologists providing telepractice? And she was reluctant to define what this would be. She said she felt uncomfortable talking about this. She feels that there should be training provided at the university level, that there certainly already is continuing education coursework that exists. She stated that hands-on training is most important, and perhaps we can consider issues such as simulation types of things where you use actors or actors to provide practice and continuing education training in a continuing education mode. The last topic that she talks about, and I'll be done in just 30 seconds, are what type of regulation. We asked what type of regulations exist in other states regarding telepractice. She said that there are some states that require that a student, client, patient be seen in person first prior to telepractice. She said that some states have regulations in which the speech-language pathologist must be seen in person, and that speech-language pathologist would then determine whether telepractice would be an appropriate service delivery model for that particular individual. She mentioned an interesting regulation in Louisiana where they have a separate licensure for speech-language pathologists and audiologists who are out of state and want to practice telepractice in the state of Louisiana, and that particular regulation states that that individual cannot then also provide in-person services in Louisiana, only out-of-state services. So there are some regulations in other states that we could consider looking at. And then she concluded by saying that there's an ethical issue when it comes to competency and knowledge and skills, and that is that if it's true for all areas of speech-language pathology, that if speech-language pathologists ethically do not believe that they have competency, that they have knowledge and skills in a particular area, then they shouldn't be providing services in that particular area. That is a piece of the ASHA Code of Ethics, and that also applies to providing services in this type of service delivery model. And that's a quick summary of the fact-finding that we learned from our Speech-Language Pathology Practice Committee meeting, and that was the only item that was on our agenda.
Thank you. Then we'll move to an update from the Hearing Aid Dispensers Committee. And now,
Yeah, the issue before us yesterday, the committee, was the type of supervision that hearing aid dispenser trainees will get from their supervisor, who is a licensee. And we are concerned that 20% of direct supervision is not sufficient enough, and it also doesn't serve the health of the public, having a trainee doing some procedure that can hurt the consumer without the supervision of the licensee. So when we discussed, we got to the understanding here, and I'll ask the member of committee if I forget something or misrepresent something, that we will direct the staff with the assistant of legal counsel to amend section 1399.119 to have basically requirement of 100% of immediate supervision for taking an ear mold impression or inspection of the ear, and 100% of direct supervision for all the other items in this section. Also, to ask that the definitions in the medical field for supervision, direct supervision, and immediate supervision will be incorporated in this section, and also to ask that it will be clear that that the licensee can is supervising a trainee, even if it's the first trainee, will have to have a 3-year license without disciplinary action. I believe right now you can have one trainee from the first day you get a license, and I think it has to be corrected. So I'll ask the board to move to have a motion to direct the staff and legal counsel to do what I presented right now.
So because it's coming from the committee, there is already a motion, and it's already been seconded. So, however, I believe the motion included that it come back to the committee first, so it can stay at the committee level for now. We don't have to have the full board vote on it unless it's your desire to do so.
So I understand that staff and legal counsel, you do the draft, so we don't need a motion by the board right now.
Not right now.
Okay, thank you.
We're moving on to item 13. This is meeting and possible action regarding communications with the California Children's Services. And Marcia, you'll be presenting on that.
On January 11th, members of the board, including myself, Allison Grimes, and Executive Officer Sanchez, along with members of CAA, including Amy White, met with a number of personnel from the Department of Healthcare Services, and especially those who work in the area of CCS. This meeting was called on behalf of CCS, so in a moment I'm going to ask Amy to come up and talk to us about it, since it was their initiative. They're working with Sacramento advocates to try to set up some sort of line of communication with CCS, because there's quite a number of breakdowns in terms of communication with them, losing audiologists who no longer want to participate in CCS because of payment issues and medical clearance issues and things like that. So we did hold this meeting, and I thought it seemed very productive at the time, but I would like to have Amy come up and we'll discuss this further.
Good morning, Amy White, CAA Board of Directors, California Academy of Audiology. So as Marcia mentioned, this is an initiative that was brought up by some of our board members and then discussed, I think, with the board here in terms of the need for action to have some meetings with CCS to address some of our primary issues. And there were a number of issues that were identified that we'd hoped to address with CCS, primarily relating to provider requirements, the application procedure and process for providers to participate in CCS, reimbursement problems, improvement in some of the regulation and policy language, and so on and so forth. And even a primary request of just having a flow chart and or one itemized individual that would serve as a point of contact, because in our experience, the issue has been as soon as we make contact or make a point of contact with someone at CCS, that position is then changed. That person is no longer in the position. And then we feel like we have to start all over again in terms of finding someone to talk to over there. So at the meeting that we had the new chief of the Department of Healthcare Services Integrated Systems of Care Division, which is, my understanding is that is now the combined long-term care services and CCS, which is now one department under that title. And that chief is Sarah Eberhardt Rios, and she attended the meeting along with 6 of her staff. So we had our goals, we discussed those, and the outcome was an agreement that there would be one point of contact that would immediately be identified following our meeting that would serve as a liaison or someone for CAA to go to when we have questions or when we have issues that we would like to have addressed to help out. And that we would be given information regarding pertinent resources. For example, we found out that some of the issues raised, for example, regarding the numbered lettered system and knowing which of those had changed at any given time, and that some of these resources already existed and none of us had any idea that they were in existence. So that CCS also offers training on billing and reimbursement, and we didn't know about that either. So the idea was we would get a list of those resources and be able to share that with our audiologists throughout the state immediately. And an agreement was that we would also have quarterly meetings, and that was actually suggested by the chief, Sarah Eberhardt Rios, and that was supposed to be set up when we left for the next meeting, and that has yet to be done. So I had a discussion yesterday with Sacramento advocates asking if they had made contact with anyone there, heard from them at all, particularly with setting up our next meeting, which should occur in April if we were going to do quarterly meetings, and have yet to hear back on that. And so far, it's been radio silence kind of on both sides. And perhaps that's our fault. Maybe we haven't identified which one of us is going to be the primary contact person, and perhaps I need to do that. So I think that's where...
I think that's the history, is that they are willing to meet. We have talked to them many times in the past. And we feel that this is becoming an access issue. It's become a consumer protection issue because we have to resolve many of these issues or we're going to be losing providers. And once we do that, or people have to travel hours to get services. So we have to be more aggressive, apparently, keep it on their radar because I guess they have many other fish to fry. And they if we don't keep ourselves in front of them, or CAA doesn't, or the board doesn't, you're seeing exactly what's happened in the past, in spite of the goodwill that we saw at the meeting.
Right.
So I'm glad you called the Sacramento advocates, and hopefully we'll keep ourselves in front of there.
Yeah, and what I will do next week is go ahead and send an email to Ms. Rios and see if we can't get some communication going again, and at least have that single person identify that they were going to appoint right after we left last time in January, so that we can set up some sort of communication, hopefully, and I'll let you know.
Okay. Thank you.
Mm-hmm.
Is there any public comment on the report you just heard? Okay. If not, we'll now take, how long, Paul? 10, 15 minutes? Yes. We'll take a 15-minute break. And I will turn it over to Karen Brandt, our administrative law judge.
Good morning. Before we go on the hearing record, I just wanted to once again give a little preview of what's going to happen since we have a new petitioner who was not here before. So we're going to start from the top on this, if that's acceptable to everyone. So the way it will work, Ms. Blanchard, is going to be like this. When we go on to the hearing record, and what I mean when I say that is I will ask the court reporter to start taking down every word. When we go on to the hearing record, what I will first do is call the case. And then I will ask once again everybody to identify themselves and establish a quorum. I will then have the Deputy Attorney General present the petition package, which are all the exhibits that you should have gotten a copy of, and she will give an overview of the petition package. She will ask that I admit into evidence all of the exhibits within the petition package. I'll ask if you have any objections. Please tell me if you have an objection or a concern. We'll hear what that is. If you don't have any, you can say no objection, and I will admit it into the record. After the Deputy Attorney General has given an overview, I will then swear you in and ask that you present your case. And what the board is most interested in hearing about is all of the rehabilitation you may have engaged in, so that it would not be contrary to the public health, safety, or welfare to allow you to practice without probationary terms and conditions. Once you have given your presentation, the Deputy Attorney General will have an opportunity to ask you questions. Once the Deputy Attorney General has asked you all the questions she may have, I will ask each of the board members whether they have any questions that they wish to ask. Once the Deputy Attorney General and all the board members have asked all their questions, I will allow both parties, both the Deputy Attorney General and you, to sum up, to describe how you would recommend this matter be decided. If you would like to make a recommendation, Ms. O'Carroll, and Ms. Blanchard, if you would like to say some final words. Once you both have had a full opportunity to present your cases, and everybody on the board has had a full opportunity to ask their questions, the board will take this matter under submission and go into closed session. The board will decide in closed session how it wants to proceed with your case. You will not get an answer today, but you will get something in the future in writing as to the board's decision. Any questions?
No.
Any questions from board members? Are we all ready to go on the record? All right, let's do that. Let's go on the record. We are on the record before the Speech, Language, Pathology, and Audiology and Hearing Aid Dispensers Board in the matter of the petition for penalty relief by Marian Blanchard, license number 8627, OAH number 2018-010497, agency case number 1C-2017-027. My name is Karen Brandt. I'm the Administrative Law Judge with the Office of Administrative Hearings who's been assigned to preside over this matter. In order to establish a quorum, I will ask each of the board members, starting first with my board member to the farthest right, to identify themselves for the record.
I'm Debbie Snow, Public Board Member.
Patty Solomon Rice, Speech Language Pathologist, Board Member.
I'm Dee Parker, Speech Language Pathologist and Board Chair.
Marcia Raggio, Audiologist, Board Member, and Vice Chair of the Board.
Amnon Shalev, Hearing Aid Dispenser, Board Member.
Karen Chang, Public Member.
Rodney Diaz, otolaryngologist, board member.
Thank you. We have a quorum. May I please take the appearance of the Deputy Attorney General?
Good morning. Appearing on behalf of the California Attorney General, I'm Megan O'Carroll.
And we have before us today the petitioner, Marian Blanchard.
My name is Marian Blanchard, and I'm a speech and language pathologist.
Thank you. And I understand that you were given notice that this was going to start at 11, but you have graciously agreed that we may start it now. Is that correct?
That's correct.
And before we went on the record, I explained to everyone the procedures that we will be following. And as I explained, the first thing that we will be doing will be asking the Deputy Attorney General to make a presentation of the petition and an overview of the case. We will then allow you to make a presentation of your case. We'll then have the Deputy Attorney General and all the board members ask whatever questions they may have. Ready to proceed?
Yes.
Ms. O'Carroll, you may proceed.
Yes, Your Honor. Now, several documents have been provided to each of the board members, which should be in binders, exhibit binders in front of you, and now have been provided also to Ms. Blanchard and to our administrative law judge. What I would like to start by doing is identifying each of these documents and requesting that these documents be admitted into evidence on hearing on this matter. As you know, the hearing on this matter is a petition for early termination of probation by Ms. Blanchard. The petition that she filed initiating this action, you will find at Exhibit B of your binders. And as you'll notice, each of the exhibits are paginated so that if we need to refer to specific documents, pages of the document, we'll be able to all know where each other is referencing. So the petition for penalty relief by Ms. Blanchard was received by the board on November 18 of 2016. It contained a series of internal exhibits that Ms. Blanchard provided, which you will find to be the narrative statement that she provided explaining her basis and of her request for early termination of probation. Also, she included a minute order from the Superior Court of Los Angeles of February 24 of 2015, as well as evidence of her online ethics course completion. Now, this matter was referred by the board to the Division of Investigation in order for them to investigate the facts and circumstances surrounding Ms. Blanchard's petition. Those documents have also been provided for you, and you will find them at behind tab C of your exhibit binders. They included, again, the petition for penalty relief, which we've included because it was part of their report, and we wanted the complete record of the report that the Division of Investigation prepared. So don't be confused. We're just including it there for the sake of completeness, but it is a duplication. Also, you'll find that the Division of Investigation interviewed Ms. Blanchard, and they recorded a summary of their findings from that interview in that report. They also included documents that they reviewed and obtained, including correspondence with Ms. Blanchard, also the minute order that Ms. Blanchard provided. They basically just attached it again, as well as a series of information and documents provided by Ms. Blanchard in her request to show support for her request for the petition. We should initially point out that the basis for Ms. Blanchard's license discipline, from which she's currently seeking early termination of probation, that occurred, and that is found at Exhibit A, the record of that. It is a decision that became effective on July 22, 2015, and that was identified by a specific case number by the agency as well. That is case number 1I 2012-70. You'll again find that at tab A in your binder. That decision became effective on July 22, 2015, placing Ms. Blanchard's speech pathologist license number 8627 on probation, subject to various terms and conditions. Specifically, the basis for the disciplinary action is described in the accusation, which is attached as an exhibit to that decision. You'll find that at pages 17 through 23. And as you can see, and perhaps have seen from reviewing it, the basis for the disciplinary action was that Ms. Blanchard was convicted of a crime, that of being grand theft, and that crime was found to be substantially related to her practice of speech pathology, specifically in that the conduct was based on her aiding and abetting the unlicensed practice. In other words, sending out unlicensed speech pathology assistants as part of her business, her speech pathology business that she was running. The terms of probation, so the license was revoked Ms. Blanchard's license was revoked, and she was placed, that revocation was stayed, with her being placed on 90 days suspension and 7 years probation. Also, there were various terms and conditions of this probation. Now, key amongst that particular document, Exhibit A, is, if you will have a look at page 4 of Exhibit A, you'll note the page numbers in the bottom right-hand corner. As part of the stipulation entering into this probation, Ms. Blanchard admitted the truth of each and every charge of an allegation in the second amended accusation, the one that I referenced being attached at pages 17 to 23. So as a result of that, Ms. Blanchard is acknowledging that she was in fact convicted of the substantially related crime. So then the question is now, she sought this petition for reinstatement, and the burden of proof in seeking a reinstatement, I should say early termination of probation. The burden of proof in such a petition is on Ms. Blanchard to show sufficient rehabilitation that would warrant such relief. Significant to recall is that Ms. Blanchard is not yet halfway through the probationary period of 7 years at the time that she is seeking this petition for early termination. Let's see.
What is the date that the probation is now scheduled to end on?
The date we see is October 22nd. And the reason that is the termination date, it's longer than would be 7 years, and that is because there were periods of tolling during the initial probation, because Ms. Blanchard was required by her terms of probation to be employed along the terms required by probation, and she had difficulty obtaining employment immediately, so that there was a period of tolling amongst that 7 years.
So it's October 2022.
Correct, Your Honor. Let's see. Before turning the floor over to Ms. Blanchard, I would just like to highlight a couple of other information and documents in the exhibit binder in front of you. Specifically, if you will turn to Exhibit D, you'll see that there was a request for additional information by the board's then enforcement coordinator, Ms. Joseph, and Ms. Blanchard. And Ms. Blanchard responded by providing additional information. Some of the additional information related to her costs and expenses, because in reviewing the petition for early termination of probation, one of the grounds or reasons that Ms. Blanchard says that she's seeking early termination of probation is because she's stating that the probationary terms are particularly onerous and that they are having a financial impact on her. And that's the reason that she's seeking relief. So as a result, part of what both the Division of Investigation and the enforcement coordinator did was attempt to discern exactly what Ms. Blanchard's expenses were and what effect the probationary terms are having on her financial situation in order to establish whether or not this undue burden does exist. So you'll find in Exhibit on pages, particularly pages 158 through 339, you will find tax documents and bank statements showing Ms. Blanchard's reported income to the IRS, as well as the expenses that she has. And I'll be asking some questions of Ms. Blanchard, and we'll be able to flesh a little bit of that out after she's had an opportunity to provide her basis and reasons. But I'm just alerting you for the moment that that is in fact there. There's also one other significant key event that occurred that I would like to draw the board's attention to, and that you will find in Exhibit E. Exhibit E is a citation and order showing that Ms. Blanchard's license was cited.
And the here 158.
Here, this is 158.
And
Oh, sorry.
the reason for that was that
Exhibit
during
B?
the course of the investigation,
Where's the tax number? Where's the numbers?
Sorry, you have to go.
160.
Sorry.
no, I can pause for a question if that would be helpful.
And let me just remind the board members, if they say something out loud and the court reporter hears it, he is obligated under the law to take it down. So if you want to say something that you do not want on the record, my suggestion is to say it quite quietly.
Was there anything I can clarify as we move forward?
He was just looking at the page number where the tax return was listed.
Oh, okay. Sure.
And what page number did you currently want us to look at?
Well, I was just referencing that the information both as to tax documents and bank statements will be found in Exhibit C, and I'm just kind of alerting you to their general location, which is quite a number of pages.
Yes.
Ms. O'Carroll, may I just stop you for a moment? I'm looking at Exhibit D now, and I see account numbers and I see Social Security numbers in the documents I have. Were you going to redact these so that we do not disclose confidential information?
You know, my understanding is that the documents that we provided were redacted.
I have in my copy, why don't we do this? When we go off the record, I will hand them back to you and show you what I have in what will be the original exhibits here.
Okay.
And I am looking and I see both Social Security numbers and account numbers in the exhibit I have.
Okay. We will definitely make sure that that is resolved before the matter is fully submitted.
Thank you.
But an additional point that is important to explain is the Exhibit E. And in Exhibit E, you'll find a citation order. This was a citation issued to Ms. Blanchard because during the course of the investigation on her petition for early termination of probation, it was discovered that certain of her employers, as part of the process, they discussed with her employers what her current status was and how she's been performing throughout the probationary period. And it was learned that not each of these employers had, in fact, been provided with a copy of the decision and the probationary order, which was a term of probation that Ms. Blanchard was required to show all future employers and to fully disclose to them the facts and status and the reason for her probationary status. So that you'll find at Exhibit E. And finally, you'll find also this is summarized in the probation report, which you'll see at Exhibit F. It just recounts generally how Ms. Blanchard performed while on probation. And then also, I've provided to you just today an additional Exhibit K to update you fully on the most recent status of probation. And so you will also find at Exhibit K, which I ask you to add to your binders now, the January 2018 probation report. So from just a few weeks ago.
And all the members have received copies of that?
Yes. And then also, as we know, Ms. Blanchard is here today, so she did in fact receive sufficient notice of this hearing. But however, you'll find her notification is contained in the record at Exhibit H, just setting the hearing for today's date and time. Finally, one significant piece of information, and some of this is will be the subject of questioning as we go forward here today, is Exhibit G. If you'll see at Exhibit G, this is a public search of the corporation, a registered corporation or limited partnership, and it shows that Ms. Blanchard did in fact have a limited liability corporation registered under her name called Rainbow Child Speech Center. And this was the business name and entity that she was using throughout the time that she was practicing when she incurred the criminal violation. You'll find that, as seen in the bank statements, that she still has a bank account open in the name of this business, the Rainbow Child Speech Center, yet the publicly available public record of this this corporation through the Secretary of State's records show that such corporation is no longer, it is now defunct. It is not validly registered with the Secretary of State. So that will be another question that we have as to whether or not Ms. Blanchard is in fact currently maintaining a business practice without being in compliance with the requirements for Secretary of State managing of business obligations and registering. As I noted, the burden of proof in this case to show rehabilitation sufficient to warrant granting the petition is on Ms. Blanchard. And you'll find that at Exhibit J, this is the legal provision I've just put out for everyone's ease of reference. This is the particular statute that lays out that requirement, and that is California Government Code Section 11522. It specifies that a person whose license has been revoked or suspended may petition for either reinstatement or reduction of penalty after a period of not less than 1 year. As we've seen, Ms. Blanchard has been on probation for more than 1 year, so she meets that requirement. However, it further states that she'll have an opportunity to be present as well as a representative of the California Attorney General's office, and the agency, you as board members, will have the ability to make that determination. If you look at California Code of Regulations, Title 16, Section 1399.156.2, and that is referenced in Exhibit I of your binder, it further states what some of the standards are for determining rehabilitation. One of the things that you as board members may consider is the nature and severity of the act or crime under consideration, any acts that have occurred subsequent to that event, as well as the length of time that has passed, and of course the compliance of the probationer with the terms of both the court and the board's probationary requirements, as well as any evidence of rehabilitation that can be submitted by Ms. Blanchard. And with that, I would move to introduce these documents that I've just referenced and described into evidence, and then I would turn it over to Ms. Blanchard to provide her evidence of rehabilitation.
I've marked for identification as Exhibits A through K the exhibits just described by the Deputy Attorney General. Ms. Blanchard, do you have any objection to any of the exhibits just described?
I do have a question when the attorney said that my business is in question right now, that is in question with the state. When I committed the crime back in 2008, 10 years ago, the business was called Dayhut Speech Center. Dayhut. And now so that one is no longer in business.
Could you spell that for me?
D-A-H-U-T. It's called Dayhut Speech, S-P-E-E-C-H, Services.
So there was one of the exhibits that you are questioning, as I understand it.
Yeah,
do you remember which letter that was?
I don't know if it's K or...
I believe it's G.
I don't know which
So
one.
that's
it's
the
G.
Secretary of State Documents, G. Why don't we do this? Why don't I reserve on ruling on Exhibit G? Do you have any objections to the other exhibits other than G?
No.
All right, so then Exhibits A through K without G are admitted, and we'll go back at a later time and look at whether Exhibit G should be admitted.
Correct.
Okay, so what I'm going to do now is I'm going to swear you in. So I'm going to ask that you stand up, raise your right hand, and I'll swear you in. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
swear.
Please be seated, and you may make your presentation. And what the board members are most interested in hearing about is all the rehabilitation you may have engaged in since your license was put on probation to show the board members that it would not be contrary to the public health, safety, or welfare to allow you to practice without probationary terms and conditions.
Good morning. My name is Marian Blanchard, and I am a speech pathologist, but my license has been put on probation for 7 years. And what that indicates is that before I go in and speak to an employer or an agency, I need to tell them that not only am I on probation, but my license is on probation. So my life is on probation. I have a lot of documentation here where I've been denied employment for working at hospitals, in clinics, in different settings. I'm a bilingual speech pathologist. I could be helping so many children and changing so many lives, but I'm not allowed to because my license is on probation. So I have to go home and wait to see who can hire me next time. I've never been in trouble with the law, ever. I don't have a speeding ticket. I don't have a DUI. I'm not a drug offender. I'm not a sex abuser, whatever. I don't have a criminal record other than the time when they came to my house, they handcuffed me, they took me to jail in front of my 3 kids. That was the one that knows it feels it. I've never even know what that feels like. I've never been passed by a jail. We're a family of immigrants. My father's a doctor. He's a cardiologist, nephrologist. My sister is an attorney. Her name is Noemi Ramirez. She is an attorney for immigration. My brother Carlos Ramirez is also an attorney. I'm a speech pathologist. I come from a family of professionals and productivity. This has been, when I came back from meeting Miss Joseph 2.5 years ago, I came in and I wanted to make sure that within that month, I completed everything I was to complete. I paid my $1,700. I made sure I was approved by the board to make sure who was going to do the assessment. It just can't be any psychologist. It has to be a psychologist approved by the board. I got that approved. I took the ethics course. I paid my fines. I did everything. At first, when I finished doing that, I realized, well, a lot of employers do not want to give me that. Like, I can't give you a job because your probation, your license is going to be suspended in the next 90 days. So I could not work for that period of time. So my first employment was in January 1st or 2nd of 2016. So I hadn't worked for 6 months. So it's very nice if you don't work when you have somebody else providing, like a spouse, or my spouse is a truck driver, so he does not make that much money. I brought documentation on how much he makes. He only makes $12 an hour for now. He just passed his A license, which he will be making now $15. But in the meantime, he was making $12. So we had to live on that amount that he made. I didn't have a choice. I did do a little bit of tutoring on the side, but I could not practice speech pathology, not even private. So I didn't work. The next thing I wanted to tell you is that I have 3 children. In college, I have my oldest one. He's in law school. I was a single mother raising my boys. I have one who goes to UCLA, my Alex. He is 22 years old right now. He's a third year of UCLA. And I have my older one who is Max Dayhut, and he is 25 and he goes to Loyola Law School. And my youngest one is 14 and she is in high school. So I didn't raise delinquents either. I'm raising professional boys as well. So I am very sorry. I am very, much ashamed because this is very much against my character, my person, my professionalism. So every time I had to explain to an employer, it would be like, no, they would look at me literally like a criminal. Like, you're going to come here and you're going to be a criminal. So no, thank you. So I have over 20 letters of rejection that it was very hard for me to get employment. So the one employment that I did get was a part-time employment. One was in Ventura County. In the morning and in the afternoon, I went to South Central. And that, I was more than thrilled, even though I had to drive 63 miles a day back and forth. But that was my way of paying the bills and, paying for my kids to go to college, paying for their books, and paying for things like that. In terms of I didn't have employment from, let me see, I did not have employment, and this was very, very nerve-wracking because my car was repossessed because I couldn't pay for it. So I couldn't pay for my car, so it was repossessed, and I had to ask my father for a loan to get my car out. I did not have employment from let's say July 2015 all the way to January 6th, 2018. So that was like a big gap of 7 months. Without employment, it is very, very difficult. I never asked the state for food stamps or welfare or whatever you ask the state for assistance. I never did. I just did what I had to do, lived within my means. I had to put a lot of things in the back burner, like the gas and I made some sort of payment arrangements. That was basically my main concern. When I hadn't worked for about over 6 months, and I finally got employment last year at around March through a company called Therapy Lounge, and I did show them because I had to get fingerprinted for a school, and Therapy Lounge sent me all the way to Port Hueneme, which is past, I don't know if you know distance, but I live in LA, and Port Hueneme is Ventura County. I had to go past Oxnard, so it was like maybe 70 miles to my employment, and I had not worked since the December before, if my recollection is fine. And this was, no, let me see, I'll tell you exactly. I had not worked since, let's say, a whole year. And then I finally got employment on March 17, 2017. I was very, very, very desperate. I didn't have a car. They were, my gas was being turned off. A lot of things were being turned off. And I do have to admit that I did tell her, I am on probation, but I did not give her the actual letter for her to sign it right away. I did give her the statement where it says I no longer have a felony, now I have a misdemeanor, but I did not make her sign right away, because then if I made her sign right away, then she would probably most likely say, you're not going to get a job. And then I really thought I was going to probably live on the streets or something. That is how desperate I was. So I was fined for that. That I do have to tell you that I was fined for that, and I am very sorry for that. But now she hired me again, and that is who I am currently working for right now. It's the same person. I did not, the same agency. I did not previously told her straight up right away, I'm on probation. I want you to sign this. This is the fact, because if I do that, I'm not going to get a job, because it never happens. I never get a job. So I said, okay, so once I'm in there, she knows, I'm a good worker. I'm helping these kids from Port Hueneme. I'm doing all these assessments, and I'm part of this preschool assessment team. she's going to realize that I am worthy to keep. So it wasn't until a month later that I told her, but then I already had I don't know the word, did something wrong. I mean, did not follow with my probation the way it should have been exactly. So I did get fined.
Anything else you wanted to say before Ms. O'Carroll has an opportunity to ask you questions?
No, not. I said just about everything.
Ms. O'Carroll, cross-examination.
Ms. Blanchard, the conviction that you sustained for grand theft, was it relating to a practice that you were running as a speech pathologist?
Yes.
And did you, in fact, did you, in fact, send unlicensed individuals and represent them to clients as if they were licensed?
They were unlicensed in this country, yes. They were licensed in other countries.
And you were aware that it was a requirement that they be licensed in this country?
Yes, I was.
Okay. So you acknowledge then that the acts that led to your conviction of theft were based on circumstances of your practice using your license?
Oh, yes, of course I do.
And approximately what was the total amount of money that the district attorney claimed that you had falsely obtained?
I think about 100,000.
And did you not tell probation and during the course of your disciplinary action on that matter, did you not explain that the reason you did it was because you wanted to have additional money to send your to support your son in law school and medical school, sons?
No, it wasn't in law school. It wasn't in medical school. This was 10 years ago. My children were not in medical school or law school at the time. It wasn't for that reason. It was the father is a trial attorney. Mm. He went to New York, and when he came back from New York, he abandoned me after my Alex was born, and he is still a practicing attorney. He went to New York, and when he came, because he wanted to stop practicing law and go into acting. So when he came back, he said, I'm going to take the kids to New York and I'm going to file for full custody. So I didn't have any knowledge of law, so I said, I'm going to fight whatever I need to do to keep my kids.
So it was in order to fund litigation for the divorce?
Correct.
However, perhaps I'm confusing. Did you, in fact, explain to the investigator that one of the reasons you're seeking release from probation is so that you can make more money as a speech pathologist now in order to support your son's schooling currently? Is that correct?
No, that's not correct. That's not correct because my father is a doctor and he has a fund for them. So my father is the one that is supporting their education. I only buy books. I pay for books. I pay for gas, and I pay for their living expenses.
You know, I'm going to ask you, if you will, to turn to an Exhibit C. If you'll look at page 37. And I'm referring to the page number in the bottom right corner.
Exhibit C.
Yes, on page 37. And I'm actually referring to...
Can't find it, ma'am.
Oh, page 30. If you look at the bottom right-hand corner of tab C.
Yes.
Do you see a page 37 there?
Yes.
And now I'm going to ask you, if you will, if you look at, you realize this is the report prepared by the Division of Investigations investigator after meeting with you.
Correct.
Okay. Do you recall meeting with the investigator?
Yes, I do. Okay. Mr. Ramos.
Okay, good. And if you look at the third paragraph, the last few sentences, do you see there where he indicates that you told him that you needed employment in order to pay for the college for your son's tuitions?
I don't know exactly where I'm looking at.
If you look at, there's a quotation there, the third sentence.
I needed my employment to pay for my college law My college law tuition. I already told you. I already told you that my father has a fund for that. I pay for their living expenses, for their books,
Okay.
and for their. That would be an astronomical.
Okay, so you think perhaps the investigator was confused as to what exactly you were referring to?
I don't know if he was confused. I don't know exactly if he would have asked me additional questions. I would be able to explain to him exactly what he was asking me.
Okay. And also in there, it indicates on that same page that your father did in fact pay the cost recovery that you're required to pay from the board, which was $14,467.50.
That's absolutely correct.
Okay. And your father provided that in a lump sum already, like initially during the beginning of your probation.
That's correct too.
And is it also true that your father paid off the mortgage on the house that you currently live in?
Yes. When my husband came back from New York, he already put he borrowed against our house. And so our house was going to be taken away. Not only was my house going to be taken away, my kids were going to be taken away by him because he's a lawyer and I didn't know better at that time. So I was very frightened.
But the upshot does mean that you currently do not have a mortgage payment.
No, but I do have property taxes to pay.
Okay. I guess the reason I'm asking these questions is that one of the reasons that you're seeking early termination of probation is you're indicating that the probation currently presents a hardship, financial hardship for you. Is that right?
Let me explain something. Is that we as speech pathologists, and if we are a bilingual speech pathologist, we make very good money. A speech pathologist does, at least in LA, and if you're bilingual. But I just lost my thought. But the part that I have a great problem is the fact that there are great spans, months and months without an employment. And that is very difficult because they will not hire you. So if I had that employment all year round, being on probation, I would still be on probation. That's not the problem. The problem is that when I'm on probation, I cannot get employment for 6-7 months. And that's really hard when you just, you pay your light, you have cars, you have insurance, you have light, you have electricity, you have phone bills, you have expenses of 2 kids, 3 kids. Your mother-in-law lives with you. You have expenses. Your husband doesn't make that much.
So is it correct then that you are claiming that the probation is presenting you with the financial hardship?
Correct.
And you also mentioned during your statement that your husband as a truck driver makes a limited amount of funds, like approximately $12 an hour. Is that right?
Yes, I have his bank statement here. And I also brought in my 1099 from the company that I worked last year, and I only made $54,000.
But I guess also partly what I'm trying to ask is, are you indicating that you were actually required to live on your husband's income of $12 an hour?
How else was I supposed to live?
Well, but that's actually my question. Did you in fact do that, or did you have alternate sources of income in addition to your husband?
I worked a little bit as a tutor.
Okay.
I worked as a tutor for my neighborhood.
One of the questions that I also wanted to ask you is that you understand that the board staff asked you for information about your finances specifically because you raised the issue of the probation presenting a financial hardship.
Correct, yes.
And they were attempting to determine your current income by requesting these documents?
Correct.
And do you feel that the documents that you provided accurately reflect the amount of income you really received?
I think so.
Well, then I'd like to ask you, if you will, if we look at Exhibit D on page 187. Now, does this show, we see that this is a bank account that you provided in response to the board's request, and it shows a corporation, a limited liability corporation, Rainbow Child's Speech Center.
Correct.
Is that your corporation that you're currently earning money through?
Correct.
And if we look at the deposits and additions, it appears there that in that particular month, which goes from December 1 through 30, that there were deposits and additions totaling $16,794. Is that money that your corporation actually earned?
Yes, I also have a contract with a company called Miracle Home Health. And Miracle Home Health allows me to go into the to the homes of the elderly, and those that have stroke, and they've have stroke, and they've had. So Miracle has that. So that is also, but it's not a very consistent employment. So some months are better than other months.
Okay. So if we look specifically then at page 171, we're seeing another example of a month, that being the month of October 1 through 31 of 2016.
What was the page on that, please?
Sorry, it was page 171. And do we see there, am I correctly interpreting it, that the corporation that you own took in a total of $18,350 in that particular month?
I got paid by 360. That's the company that I work for. Maybe for that month, but then you can check January or the month before.
Well, I noticed that there were a large number of months, and that you alternately provided bank statements from yourself, a bank statement under your own name, and another example of that would be like, for example, page 258. That's an example of your own personal bank account, and it does not show nearly as much being received and totaled.
250.
Mm-hmm. And I'm just throwing that out there as an example.
Oh, okay. This is actually, it's my account. Okay, but my son uses this account. My son in UCLA.
Okay, so
this is money I put in his account. This account was provided to Mr. Ramos to show how I provide money, how I put in money to my son at UCLA.
Okay.
So if you look at everything in there, it's things for, I don't know, all of UCLA things.
Okay.
Lyft and for his living expenses, and so that is how I support my son at UCLA through this account. So you're not going to see you're not going to see payment. It's only money that's being transferred there from my business account.
But you have access, is it correct, to all of the money in the account involving Rainbow Child Speech Center?
Correct.
Okay. So just as another example, if we look on page 212, that's showing the March 2016 income total. And there we see another example of $16,989. So the reason I'm bringing this up and asking these questions is that you're indicating that you have limited funds and your husband does not make a lot of money, and you provided tax information when inquired about your income, showing your total income for the year being, I think let's see, let me just give you an example of that. On page 314, we see your 1040 return for 2016. Page 314. And it's
301. I'm sorry.
Sure. And if we look on line 7 of that, we'll see I think it's the AGI on line 7, $32,723. But that does not accurately reflect the total income that you received for that year, right?
This is my personal account.
This
is not my business account.
And did you ever provide your business account returns?
I provided Mr. Ramos with what Mr. Ramos asked me to provide. Whatever he asked me. Here, I see my business accounts too.
Okay, I'm going to ask if you will, because you recall that in addition to the interview and request for information by Mr. Ramos, that you also received requests for information from the board staff themselves. Ms. Anita Joseph, do you recall that?
Yes.
Okay, and do you recall her sending you an email saying, the reason we're requesting these documents is in an attempt to kind of get a general sense of your total income?
Mm-hmm. Correct.
And yet, do you feel that you accurately responded to her and gave an accurate sense of your total income?
I gave her as accurate as I could. As you see, Rainbow Child and Speech Center, that is how I get paid for that. I am an independent contractor. I'm not an employee. So that is the business, and then from there I get paid.
Okay. So if you were to estimate your total yearly income, not just as an individual, but including your business income, what would you say that is?
I would say it's about 50 or 60,000.
Even though we see on any given month that you earned as much as close to $18,000?
But you understand, that's 1 month. That is not consistent. With all due respect, you're making it sound like that is what I make every single month, all the time. But that's not how it is. I've had months where I haven't had anything at all. So I provided what he asked me during. He said he wanted from March to June. Well, you work within March through June, but not all the time. In the summer, I don't work. Around December, I don't work. There are a lot of months I don't work.
And then if we were also to look at the exhibit, remember I referenced Exhibit G, and thank you for the clarification. You mentioned that during the time of the events that gave rise to the criminal matter, that your business name was not the Rainbow Child Speech Center, but instead it was
Day Hut Speech Center.
Day Hut Speech Services.
Correct.
And if you actually look on page 35 of that Exhibit G, do you see that reflects the Day Hut Speech Services? Is that the particular business you were referring to then?
No. Back in 2010, I opened up a little office in a contract with San Gabriel Pomona Regional Center. This is before I was on probation, and I registered my business as Rainbow Child and Speech Center, and this was in El Monte. I no longer have that. Okay. I no longer have any business.
Well, that's my question, actually, because as you note on page 349 and 350, the Rainbow Speech Center Limited Liability Corporation is now defunct. You understand that, right?
The office there, the office there in El Monte is no longer there. But I pay $800 a year to the state for state taxes to keep Rainbow Child and Speech Center.
Do you know then why it is not listed as active with the Secretary of State's?
I have no idea about that. I would have to check with my accountant with that.
Okay. And you do continue to use the name as part of your to operate your business under. Is that correct?
Yes, that is how I get employed through Rainbow Child and Speech Center.
Okay. But you're indicating you own the business Rainbow Child Speech.
Correct.
And then with reference to the citation order, if we look at Exhibit E, it sounded to me as though you were acknowledging that you did, in fact, fail to provide a copy of the probationary decision and order to your employers when you were gaining employment. Is that right?
Only to Therapy Lounge.
Okay. And who were the individuals that you interviewed with and that hired you in Therapy Lounge?
Her name is Maya.
Okay.
Borna. She is the CEO.
Could you spell that if you would, please?
Maya, Maya. And her last name is Borna, Borna.
And you also, did you also work with somebody named Soy, S-O-Y?
Oh, he is the case manager for Miracle Home Healthcare.
So that's a different organization that you just referred to with Maya, right?
No, that's not a different organization than Maya. That's under Miracle Home Health. That is a company that employs me as an independent contractor.
Okay.
But their employment is not very consistent. It's whenever a patient comes out of the hospital, and Soy is the go-to person, the case manager, the office manager, the one that deals with me.
Okay, but they are separate employee agencies.
Absolutely.
And may I ask if you could just wait till Ms. O'Carroll completely finishes her question before you answer, it would help our court reporter
I'm
out.
so sorry.
Ms. Blanchard, would you also now for a moment turn to Exhibit C, page 40? And again, I'm referring to the page number in the bottom right corner. I know that there are other ones in other places on the page. And you see there, when you've arrived, that the Investigator Ramos, actually interviewed Soy. I think his last name is Ibanez, Ibanez, of Miracle Home Miracle Home Healthcare Inc. And you see there that he was unaware that you were on probation at all.
He is not the owner of the company. He is the case manager.
Is he the person that you interviewed with?
No, he was not the person I interviewed with.
Is he a person who coordinates your employment?
No, he's the person that provides me with the patients. The person that knows that I am on probation is the owner of the company.
And who is that?
Her name is Hazel. Hazel, I think her last name is DeLuise.
Do you have a spelling on that, please?
D-E, and then last name L-U-I-S.
When you were asked by the investigator to provide a contact person from the Miracle Center, did you provide them the name of Mr. Soy Ibanez?
Yes, I provided the name of Mr. Soy. He asked me who is the person that you mostly deal with, the person that is your go-to person, and I told him it was Soy. I never even knew his last name was Ibanez. But he is not the owner of the company, and he's not the CEO, and he's not the person that knows how much I get paid, and he's not the one that signs my paychecks. So he is a case manager, a case worker.
Did you ever feel that it would be important to let him know of your status, since he is actually assigning work to you through that portion of the business?
Actually, the owners are the ones that know of my status.
But does Soy, in fact, refer you out to, refer business assignments to you?
Correct.
And so given that, did you think that it was necessary or important to inform him of your status at all?
I didn't think it was necessary for him for especially Mr. Soy to know. As long as the owner's HR knows, that is who needs to know, is your employer.
Okay. I'd like to ask you now to turn to Exhibit A. If you look at page 9 of Exhibit A, and this whole exhibit, it is the stipulation. Do you recognize this document as the stipulation that you signed in this case?
Yes.
And if you look under paragraph 10, again, we're on page 9, do you see the language there?
Hold on.
Sure.
And your AGO 9, not stipulation 9.
Correct. Sorry about that.
Page 9, ma'am?
Yes, on the bottom right-hand corner AGO with the 3 leading zeros and then a 9?
Yes.
And it also, do you see there where it indicates that whether you're contracting to provide speech services or that you shall notify your employer and supervisor or contractor of the probationary status?
Correct.
Since Soy was the person who was contracting or providing assignments to you through the contract, did you feel it was important that he be aware of your probationary status?
I don't think it would be important if he would be aware. I really wouldn't know the benefits of him, because if the HR and the owners said it would be okay if I am on probation and I'm still allowed to go into the community, and because I used to work for them before I was on probation. I've been working for Miracle for close to 15 years. So it's not the first time they met me. So Soy has known me for a while, so I didn't know I didn't know why it was important for me to tell a caseworker. Also, when I work in the school district, I don't tell every teacher, every custodian, clerks, office managers. I just, my agency and the principal is the people who know, or the director of special ed.
Okay. If you look also, while we're still on that page 9, do you see that there's the requirement, part of the terms of your probation required that you provide to the board the names, addresses, and telephone numbers of the people that are employing, supervising, or contracting you to work as a speech pathologist?
And I have been doing that to Miss Joseph and now to Miss Newman.
And with regard to the part on lines 14 through 17, where it actually requires that you complete and assign agreements with the employer and supervisor so that the board can communicate with the employer. Did you comply with that portion of the requirement?
Yes, I did.
Okay. And then for the citation, then you understand that you were receiving a citation, and now I'm flipping to Exhibit E, for failing to do that in certain instances.
Yes, I do see that.
Okay. So did you contest or challenge the citation that was issued?
No, because that citation was highly deserving.
Meaning that you did in fact fail to notify the board of the status of the employers you were having?
I did not notify Therapy Lounge, Miss Maya Borna, immediately. Yes, I do. I did do it within a month or so, but immediately when I first got interviewed, no, you're correct.
And when you did actually notify them, did you understand that they didn't realize that it involved sending unlicensed people out to practice, that they thought that you were sending people who were just trainees?
I provided my employer with this packet that Miss Joseph sent me.
Okay. And this packet is what?
This packet is called Declaration of Service, and this is called Declaration of Service, and it talks about my decision and order. It has before the Speech and Language Pathology Audiology hearing, Dispenser Department of Consumers Affairs. It has jurisdiction.
So it has the entire stipulation you entered into?
Exactly.
And when exactly was it that you provided that to Therapy Lounge?
I provided that maybe within the month after when I got within April or May, okay, somewhere around there. April. A month after I started working there.
Of what year would that be?
2017.
Okay. Let's see. And when did you start working with Therapy Lounge?
March, a month before.
Okay. March. So now, if we'll look on, sorry to keep flipping back and forward, but if you'll go on to Exhibit C, if you look at the bottom right number, page 39. Do you see there that the investigator from the Division of Investigation had an interview with Ms. Borna?
Correct.
Okay. And do you see there that Ms. Borna understood that there was a probationary status, but that she reported to the investigator that she thought the basis for the probation was due to inadequate supervision of staff?
I don't know exactly what she reported to Mr. Ramos.
Okay. You'll note that this interview with Ms. Borna occurred on April 13 of 2017. At that point, do you think that was before or after you had provided the full?
Before, way before.
I'm sorry, the interview occurred before you told her about it?
The interview happened first, and then I told her about it after.
So what was it that triggered you to provide that packet of materials to Ms. Borna when you did in April?
I was required. I had to do it. That's what I do afterwards. I wanted to show to Miss Borna that I hadn't worked like in 6 months, so I wanted to show her, look, I'm a very good worker. I'm on time. I can assess these children. I wanted to see my character before she judged me and did not give me employment. And I know that was wrong, and I know that's not the right way of doing it. I did not follow procedures, and that is why I was cited $1,000.
But it sounds to me as though, from what you're describing of this chronological series of events, is that you only provided the packet of materials to Ms. Borna after the Division of Investigation investigator informed her of the probationary status. Is that correct?
That's correct.
So would it be fair to say you provided it to her because she asked for it after being contacted by the investigator?
No, I provided it because that was part of my probation. I'm sorry. I always have I had a very good communication with Miss Joseph. She knew of when I was employed and when I was not employed. I have a letter that states, I am working here. I am sorry. I still have not notified my employer.
So you recognized at the time that you were doing
Absolutely.
it?
Yes, I recognize it.
Incorrect. Okay.
Yes, I do.
All right. I don't think I have any more questions.
All right, now it's the opportunity of the board members to ask questions. May I start on the other side? Dr. Diaz?
Well, I just had sort of one question or comment, just from the very beginning of the line of questioning. Just as I was reading through this, the narrative statement sheet. Just one thing that came to mind at the very end of your statement sheet. It said, "I need my employment to pay for their college and law school tuitions," which was in the very last paragraph, and I was a little confused about that with the statement that was made with Mr. Ramos's investigation. So I was just a little confused and wondering what would be the more accurate description of,
I never said the actual tuition, because even if I wanted to, I couldn't pay for it, even if I wanted to. I'm talking about their living expenses, their gas, their food, their books. That's law school. That's UCLA.
Okay, so it's
So
not.
I'm sorry I didn't-
Not actually the tuitions. That was
No,
a misstatement in your.
it's their life.
Oh, I'm sorry. I apologize. Go ahead.
No, I'm just saying that's their school. That's their life.
Any further questions, Dr. Diaz? Member Chang, any questions?
Just when were you put on probation?
I was put on probation October 22nd, 2015.
And the end of your probation would be
Probably November.
of 2022.
November 22nd of 2015.
No. The end of your probation would be,
Oh, I'm so sorry. I'm so sorry. 7 years from there?
okay, so 2022.
Now, I just wanted to clarify, Ms. O'Carroll, you told us it was
You told me it was
October 2022.
Yes, and it may be helpful, I think that may be listed in one of the probation reports.
Yeah. I was wondering if you can explain what the periods of tolling means?
Oh, is that a question for me? Yeah.
Can I ask you?
Of course,
Okay.
yes. It just, one of the requirements of probation is that you be employed. And so if at any point you're not employed during that time frame, it's considered tolled, or means taken off the amount of time that gets calculated towards running down the probationary period.
So does that mean that possibly if she wasn't working for a good 6 months, that her period of tolling might end up being 2, 3, 4, 5, like April 22nd, 2023? Is that how I'm understanding
It
it?
could happen, exactly. It pushes out the date by which probation is completed,
Okay.
but there is a maximum amount of tolling where if you are tolled for too long, then probation is revoked.
Ms. O'Carroll, if you could just point the board members to that paragraph in Exhibit A that talks about tolling, I think it would be helpful to us all.
Yes, I think they probably explain it much better than I am in the documents.
Is that paragraph 8 on page AGO 7 and 8 that talks about function as a licensee?
Yes, Your Honor. Here we go. I'm seeing, yes, on page 8 at lines 6 through 16, where it references that during periods of non-employment, that period of time will not apply to the reduction of the probationary period. But also that if respondent stops practicing for a total of 5 years, then the license shall be automatically canceled. So in other words, tolling cannot exceed that maximum amount of time.
Okay. My other question is the bank statements for Rainbow Child Development Services. I mean, that's your business bank statement, and then you had a business statement for your own personal one, but we know that is for your son, and so I was looking at the stuff. I mean, it's what most 22-year-olds would purchase and do. Do you have another bank statement of your own personal bank statement? So your Rainbow Child Services, you use that as a personal account too?
No, I also have a personal, my own personal. I just recently opened it up.
Okay.
Like I do have, but I didn't have that at that time.
Okay, so at that time you only had Rainbow?
And that one that I gave to my son.
Okay. What about your husband? Did he put? He has his own.
He has his own.
Okay.
And that's kind of basically what we do. We use his money.
Okay, and then the Rainbow Child Services, you use it as like a business expense.
Exactly.
For business use.
Exactly.
Okay.
Would it be helpful to the board if we asked Ms. Blanchard if she could tell us what businesses you have and what companies you are working for?
Okay. My business name is called Rainbow Child and Speech Center. That is how Therapy Lounge pays me. Okay? I don't have any other business. And occasionally, on some months, I may get more referrals than others from Miracle. So I don't have a business. I have a contract with Miracle, who occasionally will call me to go into a house. And 1 month, I can have 3 or 4. And the next 2, 3 months, I won't have patients.
So when you get paid by Therapy Lounge, does that go to Rainbow?
Yes.
When you get paid by, what's it called, Miracle, where does that money go to?
There, Rainbow.
So all the money you receive working from any entity goes to Rainbow?
Correct.
And then you get a salary from Rainbow?
Correct.
I'm sorry to interrupt. Please, you may
it's okay.
proceed.
So thank you for the clarification. So that salary from Rainbow, it goes into,
A personal account.
okay,
I didn't know I was supposed to bring that
okay.
today.
Oh,
I wasn't sure.
so so when did you have that personal account? Was it during this time or?
I know. I opened it up like this summer. This
summer?
Yes. So I just had that other. I wasn't very good in finances. Like if you look at my Rainbow, I used a lot of the business for personal, and I would say, sorry, this shouldn't have been done. Yeah, so I got it more organized this year.
Okay. Okay. That's all I have.
Member Shalev, do you?
Yes. Are you the sole owner of Rainbow?
Yes, I am.
No other partners?
No other partners.
When did you establish Rainbow?
Whoa, I can't recall. I think in 2010. In 2010, I think.
And you still own it until today?
Yes, I do.
Now, I don't know why, maybe both of you this question. I've looked and I found only 6 months of Chase statements. Is there a reason why we don't have more than 6 months, like 12 months? Or what who asked for the statement? Is the state asked for the statement?
Mr. Ramos provided me a list with the things that he wanted, and I provided Mr. Ramos what he requested.
Okay, so he probably requests for 6 months of statement, and you gave him 6 months of statement, which we have in exhibit right now.
Correct. I provided him what he asked me.
Yeah. Now, the income that you have reported in your 2016 1040 it's a joint income by you and your husband. And I see here 32,723. Does it represent both of your incomes?
Yes.
So what is the income from the 32,000, if you can remember approximately, will be your husband income out of it?
I don't know, because at that time, see, my husband's not from here. My husband's from Jamaica.
Yeah.
So he was only working part-time. At that time, he wasn't really working full-time. So I think most of it, whatever was there, was what I was making and a little bit what he was making.
Yeah, I know, but roughly, is it half-half or is it?
No, I make more than he does. It's not half-half. It's impossible to be
So
half-half.
he made 12,000
Yeah,
and you make
it's
30,
if that.
and you
Wait.
make 20?
Our poor court reporter can't
Sorry.
take it down when two people
Sorry.
are speaking at the same time.
Okay, so it's less than half. Now, I look at the Rainbow income for the 6 month statement that you receive, and Rainbow income was $109,446, which come to about over $200,000 a year income.
So where are you looking, if I may ask, so all of us can look at the same page?
If you look at all the 6 statement of Chase.
There should be a page number
Oh,
down
they're
the
different.
bottom.
They're skipping.
It says an AGO. Do you see an AGO number down the very right?
Yeah, I know. But I'll give you. Okay, so I'll give you one is AGO 187. This is for December, for the months of December 2016. But they are they are not in order, so there are several, but I have combined, and it's come that Rainbow income was over $200,000 a year.
Can you show me where to look?
Okay, you provide us with 6 pages of Chase. We can go on and now start looking. The first one that I have right now open is December of 2016 with 187. So we can go before and after, and then we have
I'm sorry, sir.
187.
I don't know what exhibit.
Page 187.
Exhibit D.
Is it?
Okay. Thank you.
Yeah.
There are bank statements, I
Okay.
should clarify, in both C
And
and
we
D.
get 171. It's for of October of 2016.
It's also 179,
179 is November
November, yeah.
2016. And then we have later on the first 3 months of 2017.
I was working. I was working that month.
No, I'm talking about 6 months from November 2016, October, November, December, and January, February, and March. All these 6 months.
So where did you get the 200,000?
Well, I combine all the income of 6 months. I'll tell you the 1 month was 29,337, 18,350, 16,794, 13,287, 14,689, and 16,989.
Let me tell you something. As a bilingual speech and language pathologist, my ability to make money is very good. I make very good money. I am licensed. I am bilingual. So I also treat the Latino community. But if I had that for 12 months, that would be wonderful. But I don't have that for 12 months.
Yeah, but it shows that even if you have it for 6 months, you make $109,000. That's what it shows from your record.
I don't see where the math is.
Well, so
we
can start and doing it now.
That's fine.
Yeah, I calculated it too.
You got it?
Yeah, it was 109.
I'm sorry, what is the number again, so we can all, like,
Okay,
just hear
so
it? The
let's
total number?
go. I have 171, 179, 187. Do you have the other
I have
pages?
136, 130, 136, 130. That's all I was able to find so far. I have
Yeah, but
187, 171, 179, 136, and 130. And there must be another one. If you have 6, that's only 5.
Yeah. Okay, let's go. Oh, there's 6 months here. 6 months here.
Starts at the April.
March. Okay, we have 200 and something here. Where's the?
It jumps. Oops. 136.
A deposit and addition of 212. Yeah, the March of 2000. This is 16. Okay, so maybe this is. That's 16.
Yeah.
So do we have 6 pages?
Yes.
You got them?
I'm not denying that I did not make this money.
No, okay, no, I understand. We just want to know where's the hardship coming from.
The hardship coming is from the months. Maybe I'm not a very good finance person. Maybe I don't know how to say very well. I don't know. I'm just a speech pathologist. I'm not a business person. Okay? So what I'm trying to tell you is that I do have a house, I do have expenses, and this money is not consistent. So if this would be consistent, then I would be in excellent shape, but it's not.
Yeah.
And I have a lot of letters here where it states that, I can't even be an employee to a company because they won't take employees on probation. So I don't have medical insurance, and I can go on and on if you still want to know more hardships.
I want to look at page 314, the 1040 for the year 2016.
I'm sorry, the page again, please.
Page 314. It's the first page of the 1040, the joint tax return by Marian and Jason Blanchard. You got it?
Mm-hmm.
Okay. And I'm looking here, and I don't see the business income of Rainbow that was substantial in 2016, reflected especially in in line 12. If you look at line 12, business income, I don't see it.
I don't prepare these.
Yeah, I know, but
I don't prepare these. I do personal and then I do business. So business is separate. And then I put my business expenses and everything in it.
But if you have a business, you have to pay income, you have to pay taxes. Where is the tax paid on where is the tax return for the business?
I didn't know I was supposed to bring it.
Well, this is the majority of your income.
Okay, well, I provided Mr. Ramos with. Mr. Ramos asked me every little thing. He asked me.
Do you know how much income you have from your business?
No, I don't.
No? It's your only business. You are the only person that work, no employees, and you cannot figure out how much income you made?
Because it's very inconsistent. It's not very. It's not like this is how much I make for the year.
We have 6 months. 6 months from that you have supplied us, and they are consecutive months, and it was quite consistent.
Okay, so you have 6 months. Do you have the other 6 months?
No, I mean, I don't have, but that's what we have. We have to decide on what we have as evidence. No further questions.
Member Raggio?
Sticking with that, I don't know if it's too late, but is it possible to obtain those other 6 months? To get those tax returns?
The question would be for this hearing or for a subsequent hearing you may have?
If that's necessary to be able to substantiate her argument that, yes, she has solid months where she makes good money and she has a lot of other months where she doesn't, and we don't have any evidence of that.
Oh, I have it here.
Oh, you have it here.
I have letters of rejection, if that's...
No, I mean the tax return, not the tax,
okay,
I'm sorry, the bank statements.
Okay, I see.
The bank statements.
May I suggest if Ms. Blanchard actually brought those documents and the board could look at them now, that may be appropriate. But if they are not here for you to look at now, usually we do not leave these sort of hearings open so you
Okay.
can get them later.
Okay. Let me see. Typically, I'm just curious, if things are as destitute as you say, most of us would seek employment in another industry. I understand that you've gone to school a long time. You did a lot of work to get your degree and to get your license and so on. But when one becomes destitute, we start looking for other types of employment, whatever that may be, retail, a clerical work, whatever it might be. I was just wondering if you made any attempts to seek employment in another industry.
Yes, I did tutoring. I did a lot of tutoring for little kids, for math, reading, especially Spanish. I tutored them in Spanish.
But that wasn't apparently enough to sustain
No,
your,
it was
your income
private.
needs.
It was basically private, and it was for the kids in the neighborhood.
So how about other types? Any kind of attempts?
I walked dogs around the neighborhood. I did things like that.
Okay. It says somewhere, forgive me for not finding the reference exactly, but that quarterly reports were due and that several of them were not submitted on time. I was just wondering if you can speak to why that was.
I don't recall which ones were not.
It's by Executive Officer Sanchez. There's a document in here that says most of the time they were, but these were not. No recollection?
But no. But I made sure that they got in within a week or so. They could have been late a week or so, but they got in. I never not turned them in. And I never skipped a quarterly review. They were always sent.
Okay. One last thing. You had said that Ms. Borna had a conversation with Mr. Ramos prior to you telling her, and I'm looking on, I think it's page 39, interview with Mr. Borna. You said you told her after, but she says, according to Mr. Ramos, Blanchard advised her of her placement on administrative probation with the board. So that was during the interview, prior, apparently, to you telling her about it. So she already knew, according to this paragraph.
She said she didn't know. That is why I got cited.
Well, that's confusing. Why he would say she told him that, and
If she knew, then why would I get cited $1,000?
I don't know.
I don't either.
But she apparently knew from this, if we can trust this paragraph, that she did know.
I did submit to her the minutes from that say I no longer have a felony, I have a misdemeanor. So I did submit that to her because I had to get fingerprints. And
Ahead of this interview, then.
Yes, and I just want to tell you that, and I did explain to her, but I no longer have a felony, so you're not sending a felon to a school. So
Okay.
she did know about that.
So maybe she knew some part of it.
Exactly. I don't think she knew the whole thing because I didn't tell her the whole thing.
And I would just reiterate essentially what he said. When one files a tax return and you have a business, you do have a separate tax return, but you have to move that income to your personal tax return, and it doesn't appear there. So your accountant didn't know you had a separate source of income?
I was dealing with, I don't know, I just switched accountants. My accountant was a little bit too far. He moved to Texas, so I just got this new accountant. I need to, I guess, learn more about tax laws.
Or the people doing your tax returns?
Exactly.
Yes. Okay, thank you. That's all I have.
Board Chair Parker?
Okay. I have to thank Ms. O'Carroll. A lot of the margin notes that I had have been addressed, so thank you for that. I just wanted to check and make sure I've got this right. You said that you don't work all the time. You don't work in the summer and you don't work in December.
Not all the time. I work in December. I do. I work until the school is out. And then we're
okay.
gone for 2 or 3 weeks, or depending on the school district.
Okay, because I was back adding up the 6 months.
No.
And it looked
yeah.
like there was that.
No, that wasn't, like I do work like until the school's out for the Christmas holiday, and then we come back in January if the school allows me to come back.
Okay. And the other questions that I had written out have already been answered, so thank you.
Member Solomon Rice?
Well, I have to thank the board for their questions because everything that I intended to ask has already been answered. So, so I appreciate the thoroughness of the questions, but I have no questions for you.
Member Snow?
Good morning.
Good morning.
Can you help me understand? It is in your personal narrative. I have on page 27. It does say right there that you need employment to pay for your children's college and law school tuitions. That's where it is. It's in the personal narrative. And then later, we do find out that isn't the case, that you pay living expenses, but
Correct.
not tuition. But I'm just a little confused. If you can help me understand why that exact thing is in your narrative, though.
Because when my kids started going to school at the very beginning, when they started to go into school, my kids were always in private school. They were in private school from elementary school, middle school, and high school. Okay, so when they went to college, when my son was in Whittier College, I was helping my dad paying for his expenses and also some tuition because Whittier College is a private college. Okay, so but when I went on probation, I couldn't continue helping my dad pay for the tuition. But to say that I did it on my own is not true.
Okay, thank you.
You're welcome.
Any further questions by any board members? Any further questions by Ms. O'Carroll?
No, Your Honor.
Let's do this. We've got a few things that just need to be tidied up before we go into any sort of summing up. The first is Exhibit G. Are you still wishing to offer Exhibit G?
I do. I think that it's been clarified that there was a different corporation she owned at one time, and that is also included. That's on page 351, the Day Hut Speech Services. But now we are referring to the Rainbow Child Speech Center, which has also been referenced during the course of this hearing.
Do you have any further objection?
No, ma'am.
Exhibit G is in evidence. We then talked a little bit about redacting some of the documents. There's a lot of stuff in here. What would you say to my putting it under a protective order, both Exhibit C and D? What a protective order would do would be allow everybody on the board to see it, the parties to see these documents. It would prevent people from outside coming and looking at these documents if they've got a protective order on them, and the purpose of the protective order is to make sure no one's private information is stolen. Would that be a problem if I just put C and D under a protective order?
I would request that if Ms. Blanchard is agreeable to it.
Yes, I am.
All right. What I will do is I will put C and D under a protective order. What that means is that I've got the original exhibits. I put them in an envelope that says no one other than the board or people who have need to know within the board and the parties may see them. And that's how they come to you when we send them over from OAH. And I will serve both parties with a protective order and make sure the board gets it. Okay? So I will do that for Exhibits C and D. Did anyone see any others that had information of a personal nature?
The only exhibit that I can think of that might have that issue is the actual Division of Investigation report, because let me just check that quickly. Sometimes at their cover page, they list personal information.
Usually that can be redacted easily enough. Do you know what exhibit you're on?
This would be Exhibit C.
Okay, so that's within Exhibit C? That's going under a protective order.
Oh.
C and D?
Oh, I'm sorry. Yes, you're right. You're right. I forgot about that. It's all part of the same exhibit. Thank you.
All right. All right. And as I understand it, all costs have been paid, so there's no issue with regard to that.
Yes, Your Honor.
All right. Any other housekeeping things before we allow both parties to sum up? Ms. O'Carroll, did you have any other housekeeping things?
I don't think so.
Ms. Blanchard?
No.
All right. Ms. O'Carroll, did you want to make a summing up?
Just very briefly, Your Honor. The Attorney General's office entitled to make a recommendation in cases in which it is appropriate. And in this case, we would make the recommendation that probation not be terminated early. The main reason for it is simply that not sufficient amount of time has passed. While a person is entitled to seek relief or early termination from probation after 1 year by statute, it is discretionary within the board's decision as to what they feel is appropriate on a case-by-case basis. Given the serious nature of the underlying conduct and the fact that there was a criminal conviction, and therefore the fact that the probation is not even halfway over and that it would not normally expire until 2022 indicates there just has not been a sufficient passage of time. The board's initial inclination was that 7 years was appropriate. There's been no sufficient evidence to explain why such a drastic change in reducing it to what would amount to merely 3 years, less than even half the time the board originally imposed, would be appropriate in this case. Again, it is Ms. Blanchard's burden to make that showing. And her showing has been insufficient in several regards. Some of the reasons she indicated were the basis for the grounds. The evidence is not bearing those out to be accurate. And then there's also a concern with the performance on probation, which is specifically that one of the reasons or grounds for rehabilitation to terminate a probation early might be because the probationer has performed exceedingly well on probation, better than anyone's expectations. In this case, Ms. Blanchard has not even complied with each of the requirements. It was off to a slow start in that it was told for several months, and then just complying with the terms of probation, specifically notifying employers, that has not been complied with. So given the less than stellar performance, certain issues that were raised as to being totally upfront both with the board and with employers, it hasn't been that kind of stellar performance that would warrant terminating probation this early into a lengthy probation. And with regard to some of the questions that were raised, I just wanted to point out one additional document that I think may be relevant, and this is at Exhibit D, page 159. This is the letter from then Enforcement Coordinator Anita Joseph to Ms. Blanchard in June of 2017. And you can see that following up even on what the Division of Investigations investigator had requested from Ms. Blanchard, Ms. Joseph really kind of broke down, like asking Ms. Blanchard to provide additional information, and she even broke down the reasons for it. For example, if you look at number 6 of this letter on page 157, really the crucial question comes down there, where Ms. Joseph aptly asked what her current average monthly household income was. So I think it should have been clear, and I think it was clear to Ms. Blanchard, that the purpose of the request for these documents is to get an idea of her actual real income from whatever source, and that was not provided, and the answers that we've received have been less than forthcoming. And I think the reason for that is simply because the claim of financial hardship is not really borne out by the evidence. So for all of those reasons stated, I would posit that termination of probation at this point in time is not justified by the showing that's been made.
Thank you. Ms. Blanchard, did you want to sum up?
Yes, I just understand what would be the benefit of continuing keeping me on probation. I am not hurting anybody. I am working right now for a school district that was uncovered for 2 years. These kids are in South Central. They have not been served. I went in there and I am currently serving them. I am changing lives. I am helping the staff, the students, the families. I am actually helping children. I am not hurting them. This is not really about money. If you really look at it, this is really about my own person, my soul, and my self-esteem and my self-worth. okay? I am unable to be an employee at any company. The last I worked, like I told you before, when I work, I make very good money. When I don't work, I make no money. Mr. Shalev said that $100,000 should be carrying me for the whole year. I'm not a financial planner. This is not about that. What I am saying is that I have plenty of letters here, plenty, and I would love to share them with you if you would like to, that I have been rejected from this company, from that company. I've been rejected from the help group, which is 5 minutes away from my house. I've been rejected from Pasadena Unified School District. I've been rejected from LAUSD School District. I have it right here. Here we can get benefits, we can get insurance, I don't have any of that. So that I've been rejected from there too. I've been rejected from, I had a contract with the Department of Social Security. I was their main assessor for 13 years, okay? And they were very happy with me, and I kept all my reports on time and assessed every single one of, I had sometimes clients waiting for me outside the door. And I had that contract for 13 years, and because of me being on probation, they terminated that contract. So here's another one that I've been terminated from. I no longer have a felony. I have a misdemeanor. Okay? Right now, I'm working at a place where it's 63.4 miles from where I live. I go there every day, back and forth. If I was late bringing my evaluations to the board, it must have been a week or so. I never not sent one in, ever. If either employed or not employed, even when I was cited. So to say that I was not forthcoming, I've been forthcoming. And I provided everything Mr. Ramos told me to provide. Now the board is asking me they want additional. That was not asked at the time of the investigation. At the time of the investigation, I provided everything Mr. Ramos wanted me to provide, and I was forthcoming with everything. Even the fact that I had not completely told Ms. Borna that I was on probation. And that was because I had not worked for the previous 6 months. It is not an excuse. It is exactly what happened. So I just don't see the benefits of like I haven't been on probation enough. Okay, so I'm probation another 5 months, another 5 years, 6 years. How is that gonna benefit anybody if you continue to keep me on probation? There's so many different lives that I can change and I can help, but I can't do it because I'm on probation. So I only can work where an employer is desperate enough because they've not had a therapist for a year or two. And it is not like close to my house, so it's the wear and tear of my car, gas, stress, emotional stress, that sometimes I have money and sometimes I don't. So all of that I'm taking into consideration. So if you guys can find the benefit of continue keeping me on probation, continue to keep me on probation. If you find there's no benefit, then I'm going to leave it into your hands. Thank you very much.
Anything further from any board members?
I have one question. You just said that you provided anything requested by the state. We saw in the letter that Anita Joseph sent you when we refer, I believe, to number 6. What is the average monthly income? Did you provide an answer to her? What was your average monthly income?
Like how much I make per month?
Yeah, did you provide an answer to this letter?
Because I didn't have an answer.
So I'm sorry.
I mean, it can be 0. This is an answer.
I didn't know how she wanted me to answer because I didn't have a a regular, I wasn't working every single month. But if I had to say in 1 month, a month that I work for 1 month could be 0. For my other month could be up to 10,000.
That's why this was the word average.
Okay.
Thank you.
Did I answer your question?
Yes.
Anything further?
If I could just add, Ms. Blanchard referenced several documents and letters, and those were included. They were already provided, and so the board does have them at pages 63 to 82. It wasn't quite clear. It seemed as though she may be referencing additional documents. But just to reassure you, you do in fact have those.
Where, excuse me, where are they?
At pages 63 to 82, showing attempts to obtain employment and letters denying employment that I think you referenced, including the Department of Social Services letter I believe you were talking about.
I just see the Department of Social, I don't see any other reference to that.
Okay, well, I was...
Oh, I see LAUSD.
As I understand, Ms.
Yes,
O'Carroll's, that's it? That's
Yes.
So you have nothing further you wish to offer?
Correct.
That's all the point I wanted to clarify.
Matter submitted?
Yes, Your Honor.
All right, the matter has been submitted to the board. As I said earlier, the board will go into closed session to deliberate. When the board goes into closed session, everybody not participating in the closed session must leave. And the board will be issuing a decision sometime in the future. Thank you so much. The matter has been submitted and the record is closed.